Hello, and welcome back to Business Law Online. This is the second lecture of real property, um, which we're going to be finishing off that subject in this lecture. When we last left off, we were talking about zoning laws. Now, zoning laws, what they do is they regulate the use of property. They do a couple of things. One, they set up use districts. So a town, for instance, would be divided into residential areas, commercial areas, industrial areas, and actually the definitions of these zones has become a lot more specific. It used to be just residential, now it's residential A, B, C, D, E, depending upon what type of personal residence you're building. It could be, for instance, an apartment building. So an apartment building may be residential D. Um, a much bigger home, like what would be considered a luxury home, might be residential A. So it varies. It varies. Same thing with respect to commercial districts. There's retail commercial, there's professional commercial, and everything in between, as well as industrial. You have light industrial, you have heavy industrial. So that's what it does. So it sets up use districts. It also establishes aesthetic requirements, what your building has to look like. Zoning laws are becoming more strict, without a doubt. I mean, in my town alone, my little village, you can't cut down a tree without a permit. So zoning laws are getting a lot stricter, but they set aesthetic requirements. They also set building size requirement, height, size, width, all that stuff. So how big you can, how tall you can build your building, your premises, whatever the case may be, is covered by zoning laws. Zoning laws also cover parking, and this is particularly important. And this is actually a relatively recent development in terms of zoning laws. It used to be that so long as the property was zoned appropriately, commercial or industrial, that was enough. You could do what you want to do. But now, it covers parking. So usually there's a formula. If you have 10,000 square feet of commercial space, you have to provide, say, maybe one parking spot for every 1,000 square feet. So you have to provide 10 parking spots. So that's also something that's covered by zoning laws. I want to talk briefly about environmental laws. Environmental laws are increasingly becoming more and more important. And the fashion industry, as it is all industries, is impacted by them. The first one that you should know is the Environmental Protection Act. That was passed in 1970, and that established the Environmental Protection Agency. And that is the federal agency in charge of enforcing most federal environmental laws. Not all, but most of them. They conduct investigations, they hold hearings, and ultimately make determinations, judicial determinations. They also draft regulations enforcing environmental laws. Very powerful agency. The next act that you should know is the Clean Air Act, and as the name suggests, it regulates the disposal of pollutants into the atmosphere. There's also the Federal Water Pollution Control Act. Again, as the name suggests, it regulates the disposal of pollutants into our waterways. All industries are controlled by this, including the fashion industry. And these last two I'm going to cover are really important. The Toxic Substances Control Act. What that does is it requires manufacturers and processors to test new chemicals and compounds to determine the effect on human health and the environment, and to submit those findings to the EPA before they can be marketed. Very important. So if you have a new chemical of some kind, it's got to be tested for impact on human health and environmental health, and those results have got to be submitted to the EPA before they will let you market that new chemical. There's also the Resource Conservation and Recovery Act. And what this does is it regulates the disposal of hazardous waste into the environment, including the fashion industry. Now, the fashion industry, does it produce a lot of hazardous waste? Absolutely, you bet it does. What's probably the most common natural fiber in use in all apparel and accessories today. Cotton. Cotton, cotton plants are susceptible to insects. There are a lot of insecticides used and fungicides to protect the cotton plants. All those poisons, basically, insecticides, fungicides, herbicides, they all are, they're all released into the environment and can pollute it. So absolutely, that's part of it. What about leather goods? Well, leather, as you know, comes from cowhide, but you just can't take the leather after it's been removed from the cow and wear it. You gotta process it. The process is called tanning, and tanning leather requires lots of different, really caustic chemicals, and those chemicals are, of course, discharged into the environment. So the fashion industry is covered by environmental laws. It's just something you got to be aware of. All right. Last lecture, we discussed the different types of estates in terms of ownership. Okay? Freehold estate and concurrent estates, we talked about those two types. This lecture, I want to focus mostly on, well, for the rest of the class, or this lecture, I want to focus on leases. Really important part of it. Leases are obviously very common. I'm sure many of you have leases with your landlord. So hopefully you may find some of this useful. Now, leases are governed by the UCC, the Uniform Commercial Code, Section 2A. Now, what is a lease? Well, it's a legal relationship between two parties, two or more parties, and it grows out of a freehold estate. Now, remember last lecture, what is a freehold estate? The key to any freehold estate is a present possessory interest. So you've got to have a present possessory interest. Now, a lease is we have two parties, landlord and the tenant. The landlord is giving the tenant the right, their right, to possess that property. They're not giving them the right to title, to ownership, just possession. So that's important. But as we discussed at the beginning of the last lecture, leasing and owning are very similar in terms of rights that you have. But nonetheless, what is a lease? It grows out as a legal relationship that grows out of a freehold state where the landlord gives the tenant the right, its right of possession. Now, a lease, it could be written or it can be oral. Leases are extremely informal. And what I mean by that is that really everything is up for negotiation. No matter what it is, you can negotiate it. I want to go over some stuff that should be in a lease at the end of this lecture, and we'll talk about it in more detail. But what if the lease is expected to last longer than a year? Should it be in writing? Well, remember contracts under the statute of frauds, anything that may take longer than a year needs to be in writing. So if the lease is going to take longer than a year, yeah, it's got to be in writing. All right, I'm going to go over the 4 different types of leases. Oh, here's my cat again. Here she is. Gemini. Good girl. She's a good girl. It's just a matter of time before she makes her appearance. Anytime I'm giving a lecture to you, she shows up. But I just I thought I'd give her a little spotlight. All right. There are 4 types of leases. The first type of lease is the most common type of lease, and it's what most people think of when they think of a lease, and that's a tenancy for years. What that means is the landlord and the tenant agree on 2 things. 1, the duration of the lease. 12 months, 13 months, 2 years, whatever the case may be. 2, they also agree when rent is due. Now, a tenancy for years automatically terminates at the end of its period. Once it's up, it's up. The landlord does not have to take any steps in order to terminate the lease. It terminates automatically. And neither, conversely, does the tenant. The tenant doesn't have to take any steps. Once the lease is up, they're free to move out, and that's it. So that's a tenancy for years. The next type of leasehold, these are really leaseholds that I want you to know about, or tenancies, is a periodic tenancy. Now, with a periodic tenancy, you may know this more commonly as a month-to-month tenancy. The landlord and the tenant, they don't agree on the duration of the lease, but they agree when the rent is due. And usually it's the first of the month. Now, with a periodic tenancy, it can be terminated by either party, but only upon reasonable notice. And in New York, at least, reasonable notice is defined as a month. So you have to give a month's notice if you're either the landlord or the tenant to terminate a periodic tenancy. Usually, periodic tenancies grow out of tenancies for years. You know, if you have a 12-month lease, the lease is up, but the first day of the 13th month, what do? You write your rent check, give it to your landlord cashes it. Well, you've gone from being a tenancy for years to a periodic tenancy. The next type of lease I want you to know is a tenancy at will. A tenancy at will. Now, a tenancy at will, we don't have those in New York, in most northern states, but it's kind of common in the South and in the West. Basically, it's a lease that can be terminated by either party at any time. So tenancy at will. And the last type of tenancy is what's referred to as a tenancy at sufferance. These are actually kind of common. What a tenancy at sufferance is all the tenant has is possession without the legal right to possess it. So, for instance, you have a tenancy for years, for 12 months. The 12 months are up. 13th month, first day, tenant is still there. Tenant doesn't pay rent of any sort. And if they're not paying rent, then obviously the landlord can accept the rent, so you don't have a periodic tenancy. But the tenant remains there. In essence, in a sense, the tenant's become what? A squatter. But a tenancy at sufferance. It's when the tenant just has naked possession. No legal right to possess the premises, but they possess them nonetheless. All right. Now, we talked about the different types of leaseholds, right? The 4 different types of leaseholds. What about duties, a tenant's duties under the lease, regardless of what kind of lease it is? Well, number 1 is what? Obviously, pay rent. That's the number 1 tenancy, to pay rent. And if you're late with the rent, well, the landlord can charge what? Reasonable late fees. What's reasonable? It's up to the court. Reasonable may actually even be agreed upon in the lease, that if the tenant is late with the rent, landlord can charge reasonable fees. Sorry about that, I just got distracted for a moment. But anyway, that's number 1, duty to pay rent. But what about other duties or responsibilities? Well, a tenant does have other duties and responsibilities depending upon what type of lease it is. There are 3 basic types of lease. You have a double net lease, you have a triple net lease, and you also, you have a net lease, you have a double net lease, and you also have a triple net lease. So you have a net lease, double net lease, and a triple net lease. And they are a little bit, doesn't really make sense. And when I go over it, you'll understand why. With a net lease, the tenant, of course, is responsible for the rent. But in addition, they're responsible for paying an additional expense related to the property. It's usually property taxes. So if a tenant has if the landlord and the tenant agree upon a net lease, the tenant is agreeing to pay the rent and usually the property taxes. But it doesn't necessarily have to be property taxes. It's just one other item. If it's a double net lease, and this is where it gets a little bit deceiving, double net lease assumes what? They're paying 2 things. But they're really paying 3 things. They're paying the rent and usually 2 other items. They're usually property taxes plus the utilities. Now, it doesn't have to be property taxes and utilities, but it's 2 additional items. So maybe that's how it makes sense. Double, 2 additional items. Finally, there's a triple net lease. Now, a triple net lease is where the tenant agrees to pay not only the rent, but also 3 other items. And it's usually property taxes, utilities, and insurance. So that's referred to as a triple net lease. But again, you're really paying 4 items. I guess it's assumed with all leases, the tenant is always going to pay rent. It's just a question of how many other things beyond that. All right. Now, what about the landlord's duties and responsibilities? Well, if you're the landlord of commercial real estate, you're in a pretty good situation. You don't really have many duties except to transfer possession. But if you're a landlord of residential real estate, uh, every lease, whether it's in it or not, has the implied warranty of habitability, whether it's in the lease expressly or not. And it's implied in every lease. The law implies it. The landlord cannot say in a lease the implied warranty of habitability does not apply to this lease. It's implied in every lease. And what it states is that the lease premises is fit, safe, and suitable for ordinary use. For instance, there's no unchecked vermin infestation, mice, rats, cockroaches. There are no leaking roofs. The bathrooms are workable. The water is workable. The appliances work. Stuff like that. The implied warranty of habitability. That it's fit, safe, and suitable for ordinary residential use. So if, for instance, an apartment is infested with mice, that would be a breach of that implied warranty, and the tenant can get out. If the toilet doesn't work, that's a breach of the implied warranty, and the tenant can get out. If the heat doesn't work, again, that's a breach of the implied warranty, and the tenant can get out. Now, what if the landlord violates this warranty? What are the options for the tenant? Well, there are a couple. One, they could withhold, they could repair the problem and deduct that amount from the rent. And if you're going to do that, what should you do? Well, you should make sure you get an invoice, a written invoice, make a copy of it, clearly stating the amount, and then sending it to, when you send your rent check with a deducted amount, sending it to the landlord, indicating why the rental amount is less. You could do that. You could withhold the amount of rent that breach of warranty reduces the value of your apartment. So, for instance, suppose, for instance, your apartment has 3 rooms and there's a leak in 1 room. Well, I mean, that's, 1/3 of your premises is not usable. So you could deduct, arguably, 1/3 from your rent. You could do that. You could also pay the full rent and then sue your landlord for damages. For instance, the cost of having to make those repairs, or the reduced value of the leasehold. You could sue for damages. The first 2 remedies are referred to as self-help. In other words, you're doing it on your own without the court's intervention. This 3rd remedy, you're going to the court. You're asking the court basically to give you the damages that were paid to have the repair made, or if the lease isn't as valuable because of the breach, to have an award of that amount. So you're going to the court to get a court order, basically a judgment. Or 4, if the breach is bad enough, you can claim constructive eviction. That is that the landlord has basically evicted you. So constructive eviction, and you just stop paying rent altogether. All right. So those are what a landlord can do. Now, what about the lease itself? What about the lease itself? Is it possible, for instance, to sublease? Yeah, absolutely. It's possible to sublease, and we're going to go over that. I want to go over what should be in a commercial lease. All right. Well, number 1, what should be in every commercial lease? 1, the names of all the parties. Now, this will go into a residential lease as well, but if it is a commercial lease, make sure you have the legal name of the business. We haven't covered that yet. We're going to cover that when we cover um, business organizations. But businesses have business names. If you have a partnership, it's usually the name of a couple of partners, or it could be a DBA, a doing business as. A corporation is a separate and distinct entity, so you want to put the name of the corporation on it. Now, the landlord may decide, no. I don't want the name of your company on it. I want you individually on it. In other words, I want you personally on the hook for this lease. That's up to you if you want to do it or not. I mean, I would try not to, but it's entirely possible that it may happen. So the name of the parties should be on the lease. A description of the part of the property should be on the lease. A street address might be enough, but sometimes with street addresses, it's not enough. What if the street address is shared by multiple tenants, for instance? Also, street addresses don't often match up to the legal description of the property. Ideally, you should have the section, block, and lot number of the premises. The section, block, and lot number of the premises, they're maintained by all local governments, and it's a legal description of the property, basically describing it in terms of metes and bounds. What does it look like on a map? So the section, block, and lot number is ideal, but definitely you should have a description of the property on it. The term of the lease should be stated, the starting date and the end date. Now, here's where you may have to think about things a little bit. If you believe the economy is getting stronger and the rental market is improving, would you want to enter into a long-term or a short-term lease? Well, long-term. Absolutely a long-term lease. Why? Well, if you're getting it, say, $20 a square foot at the beginning of the term, maybe by the end of the term, that same space is worth $25 a square foot. And now you have to sign a new lease, and you're paying more. Now you may want to lock in $20 a square foot for 5, 6, 7 years or longer, or whatever you may think the direction of the economy is going. What if, on the other hand, you believe the rental market is going down? Would you want to sign a short or long-term lease? Short-term lease. If you're paying $20 a square foot, but at the end of the lease it's only worth $15 a square foot, but you're in a long-term lease, then you're overpaying $5 a square foot. Why do that? So the terminal lease, really important. The rent, of course, rent. It's got to be in a lease. And two things there is, one, the amount of the rent, and two, how often is it paid? Usually rent is paid at the first of the month. I've seen leases, though, that's paid every 3 months or paid every 6 months. It's possible. You can negotiate anything you want. However, and usually landlords are willing to give you a little break on the rent if you pay more up front. You pay 3 months in advance, 4 months in advance, etc. But as a tenant, though, what important leverage do you lose over your landlord once you pay the rent? You've paid the rent. The one thing a landlord always wants is their rent. So you have that as leverage over them month after month. To see to it, for instance, that repairs are made, for one thing. That other issues on the building are addressed. So stuff like that. So the rent. Also, the security deposit. How much of a security deposit should be in the lease? As a tenant, obviously you want to pay as little as possible. Now, what is the security deposit for? Is it for the last month's lease, or is it for repairs and damages after the lease? It's for the latter. It's for repairs and repairs of damages after the lease. It's not for rent. It's not for rental arrears. So that's something that you've got to keep in mind. What else should be in a commercial lease? Well, how about, for instance, renewal terms? Is it going to be the same terms or something different? My feeling is, probably have different terms either way. What about the activity that actually goes on the premises? Now, I've seen leases that state, illegal activities cannot be carried on the premises. If you do engage in illegal activities, that's a breach of the lease by the tenant, and they can be evicted. Fair enough. Well, may seem clear. I think we all know what illegal activities are. But what if, for instance, you lease the premises for a gardening supply distributor? Gardening supplies often includes lots of fertilizer. Well, explosives, if you don't have a license for explosives, explosives are illegal. Fertilizer can be used as an explosive. So I'm always a little bit hesitant about that. Illegal activities. I've actually even seen leases state that immoral activities are cause for breach of the lease by the tenant. That's even broader. We talked about this a couple of classes ago. What is an immoral activity? Well, that's highly subjective. Immoral by whom? By the tenants or the landlord standards? So be careful of language like that, broad language like that, illegal, immoral, stuff like that. To me, I think a lease, if I was representing the tenant, when I represent a tenant, I always say that nothing inconsistent with state, federal, or local laws shall be carried on. Something like that. Not necessarily illegal, but nothing inconsistent with federal, state, or local laws. It's a little bit more concise. What else should be covered? Well, subleasing, absolutely. Chock full of nuts made a lot of money. How? Well, they entered into, in the 60s, they entered into long-term leases, lots of property, all around Manhattan and other city areas, for coffee houses. Starbucks was not the first coffee house craze. In the 60s, there was late 50s into the 60s, there was a coffee house craze. And chock full of nuts basically had chains of coffee houses. Now, the coffee houses didn't do really well, but the leases actually turned out to be assets for chock full of nuts. Why? Because they were long-term leases entered into in 1960s prices. So they ended up actually doing really well. They were able to sublease the property. Now, with subleasing, if I were to represent the landlord, at the very least, I would want to be able to give approval to the sublessee. At least that they should have the same credit as the original tenant. Subleasing is fine. It's common in commercial leases and also residential leases. But representing the landlord, I'd always say, I want approval for this. I want to give approval before you do sublease. Now, what about the relationship between the original landlord and the subleasee? Well, there is no relationship. If the subleasee doesn't pay the sublessor/original tenant the rent, the sublessor original tenant can't say to the landlord, I can't pay you the rent because the sublessee is not paying the rent. No, there's no relationship. The original tenant cannot tell the original landlord, go get your rent from the sublessee. No, there's no legal relationship between them. So the legal relationships, the original legal relationships between the landlord and the tenant remain intact. There's just a new relationship between the tenant/sublessor and the sublessee. But there's no relationship, no legal relationship whatsoever between the original landlord and the sublessee. All right, what else should be in a lease? Well, repairs. And usually, in commercial leases, the tenant is responsible for repairs. Certainly repairs on the inside. Sometimes the landlord will be responsible for big ticket items like the roof, the walls, the heating system, stuff like that. But generally speaking, tenants are responsible for repairs. But it should be covered in the lease, one way or the other, to make sure who is responsible for this. So repairs should be covered. What about alterations and improvements? Yeah, that should be covered as well. And usually, again, in the commercial lease, who's responsible for them? Well, it's usually the tenant. But again, there's no formality to a lease. Everything is up for negotiation. Now, with alterations and improvements, if you were a landlord, what would you want? you would probably want approval to get before those alterations or improvements can be made. This is one we covered when we discussed the net lease and double and triple net lease. Property taxes. Who is responsible for the same? Usually a commercial lease is the tenant, but again, it's up for negotiation. But it should be addressed. This next one, insurance, really important. Got two types of insurance: property insurance and liability insurance. Property insurance, that basically covers if the building burns down, who's going to maintain the insurance to get the insurance money to build the building back up. Usually it's in commercial leases, usually it's the tenant, but not necessarily. Again, it's up for negotiation. Liability insurance. Well, what if someone comes onto the premises and they're injured? Well, that party, they can sue not only the tenant, but also the landlord. So who's going to maintain the liability insurance? Now, with both insurances, whoever maintains it, the other party should negotiate that they're an additional insured. Now, usually, it's the commercial tenant who buys the property insurance and also the liability insurance. Now, if I were a landlord, I would still buy my own insurance just to make sure. But with that being said, if the tenant is buying the property insurance, if the tenant is buying the liability insurance, if I were the landlord, if I represent the landlord, I would insist in the lease that the landlord is listed as an additional insured. What does that mean? That means they're also covered by the policy. Very important if you're a landlord in particular. But insurance should be covered as well. Utilities. Who's responsible for paying utilities? Signage is another big issue. Usually, if you're a landlord, I would want sign approval. But if you're a tenant, you may not want that. I mean, part of your branding, for instance, as well as your alterations and improvements to the premises, it may all be part of your branding. Maybe you don't want to have the landlord give responsibility for that. But still, signage, that should be covered. At the end of the lease, suppose you move out. Who owns the sign? At the end of the lease, when you move out, who owns those improvements and alterations to the building? Who owns them? It could be, for instance, you put in a bar. Well, who owns that bar? Usually, any improvements or signage at the end of the lease reverts to the landlord. But again, that could be up for negotiation. If you're a landlord, commercial premises, you should have a right to enter the premises to inspect them every so often. Now, with residential leases, it's a little bit different. With residential leases, a residential tenant has a right to quiet enjoyment. What does that mean? That means the landlord just can't barge in on you. Unless it's an emergency. You have a right to quiet enjoyment. The landlord just cannot barge in on you. But with commercial leases, it's a little bit different. The landlord should maintain, maybe upon reasonable notice, the right to enter the premises for whatever reason. Parking should be addressed. Yeah, you have the building, you're leasing the building. Now, what about the parking? Do you have any spots? That should also be addressed. Building rules. What are building rules? Well, this mostly applies to professional commercial real estate. Not retail real estate as much as professional commercial real estate, where you enter into a building, into a lobby. Usually, for instance, the lobby looks really nice. Right? It leads to an elevator bank, brings you up. Maybe even there's someone, a doorman of some kind, or an elevator operator. The lobby looks nice, maybe even marble floors and the such. So what would building rules apply to? Well, suppose, for instance, you're a new tenant in that building, and you do want to make some alterations, say, to your office space before you open up. There may be building rules, for instance, that tradespeople cannot go through the lobby entrance. There'll be a service entrance, usually in the back somewhere. Why? Because those tenants are paying a lot of money for this really good-looking lobby, and the last thing they want is what? Tradespeople going through with their tools and equipment, messing everything up. So a building rule, for instance, would cover that. You got to go to the back to get entrance to the building. That's pretty common. A hold harmless or indemnity clause should also be addressed. What does that mean? Well, who's responsible if someone gets injured? So, for instance, hold harmless clause may state that the tenant will hold harmless the landlord for any injuries arising hereunder. What does that mean? If someone's injured on the premises and they sue the tenant and the landlord, well, if the landlord has to pay any money, the tenant will pay that amount. That's a hold harmless or indemnity clause agreement. So that should also be covered in a commercial lease. All right, that's it. Keep up to date with the work. You're doing good work, and by the end of the week, I'll have another lecture posted. All right, bye-bye.